All
right, good afternoon. My name is Vihul. I'm the CEO of a company called CyberLaw International. This is a company that provides training and consulting services in international cyber law. So what this means is that actually we'll be taking a small detour from data protection and privacy laws this afternoon. And instead, what I'll be talking about is how a different body of law affects the cyber operations that private companies might be engaged in. In other words, we'll be talking a little bit about cyber conflict, cyber war, and as we're about to do it, the computer crashes. So I don't know what the computer must be sensitive to those issues, I suppose.
Just a minute.
Before I founded my company, I actually spent 9 years at the NATO Cooperative Cyber Defense Center of Excellence in Tallinn, Estonia. And like I said, I am not a privacy lawyer, but rather I do public international law. So that's what I'll be talking about today.
Okay, I think this was very useful introduction.
All right, we're live. So how does this work?
So you push here for 4.
All right. Okay, so coming to the issue of what is the law that governs those cyber operations that private sector entities might be engaged in. As you know, this is not just a hypothetical, but rather we're seeing increasingly more companies, whether they are defense contractors, cybersecurity companies, or even hardware and software producers, engage in cyber operations that are directed against other states. So when we talk about the law that governs those activities, then first of all, of course, we are talking about the domestic laws of states. And because we are talking about transnational cyber activities, it is clear that those cyber activities implicate the domestic laws of many states. Of course, these have to do with privacy rights of individuals, which is the topic here in this session. But also, very importantly, those activities may implicate the criminal laws of the states that are somehow involved in those cyber operations. The important aspect for private companies is that not only does a private company that engages in those cyber operations need to comply with the law of that state where that company is based, but also with the domestic laws of the state against which those cyber operations are targeted. As you know, this may sometimes result in conflicts of law. Sometimes an activity that your company engages in your home state may be lawful there, but breach some rules in the target state. This is clearly evident by virtue of the fact that Google, for instance, has to filter certain search results that are coming from European IP addresses, but not from, for instance, US IP addresses. So this is an example of how domestic law implicates, how a cyber operation implicates the domestic laws of many states, and there is also a so-called conflict of law. For private companies, of course, the domestic laws of the states that are implicated are of primary relevance. Why? Because often those domestic laws directly address the issue at hand. In the case of cybercrime, for instance, there are very specific provisions. And secondly, because domestic laws are effectively enforced. So this is much more of a legal risk for companies than what is called public international law. But that's what I'll be talking about. Even though domestic law is of primary relevance for companies, private companies, it is public international law that also has some operational consequences for those companies that decide to engage in cyber operations directed against other states. Public international law is also known as the law of nations. This should tell you that public international law is predominantly concerned with the relations between states. In other words, very seldom does it address directly private entities or non-state entities, and very seldom does it create rights and obligations for non-state entities. Nevertheless, like I said, there are some operational implications, and that's what I'll be talking about. And I'll look at those public international law implications from two perspectives. The first is when a company engages in cyber operations that are directed against another state, and does so somehow in cooperation with a state. So there is some nexus between the private company's operations and a state. And then secondly, I will look at the situation where a private sector company is acting autonomously vis-a-vis another state. For instance, it is engaging in some sort of intelligence collection. As I go through the law, I'll be relying in great part on a resource that was produced in Tallinn, Estonia between 2009 and 2017. It's called the Tallinn Manual. Has anybody here heard of the Tallinn Manual? Okay, a few people have. So this was an expert-led process that took 7 years. It was done, like I said, under the auspices of the NATO CCD COE in Estonia. And this is a very useful resource in understanding how international law applies in the cyber domain. If you plan on getting this book, you should know that it's the green edition, that is the current one. That's the one that was published in 2017, this February, whereas the blue one was published in 2013. So the blue one was effectively replaced by this book. So looking at companies acting somehow in connection with other states. The first question that we ask from a public international law perspective is, well, can we attribute the private company's cyber operations to that state that has some sort of an involvement in that cyber operation? In other words, the legal question is that of attribution. So we ask, can we attribute the private company's operations to that state? The legal threshold is on this screen here. It says that the private company has to be operating on the instructions or under the direction or control of a state. In other words, when this is the case, we attribute the company's actions to that state as a matter of law. Now, those are both very high thresholds. What we mean by instructions is that the state has somehow authorized the conduct of the private company, and then the private company becomes an auxiliary of the state. It remains outside of the official structure, right? It remains a private company. It is not anyhow transformed into an organ of the state, but it is operating on the instructions of a state. And then the second test, direction or control, which lawyers here will know is interpreted as effective control, means basically that the state controls the operations of the private company. So the state has the capacity to turn to that private company and tell that company to engage in a particular cyber operation. So these are the legal thresholds. We have to establish that the private company, let's say Kaspersky, that hit the news recently, is operating on the instructions or under the direction and control of a state. When that is the case, then what happens as a matter of international law is that the target state may claim that the state that had an involvement in the cyber operation is responsible for a breach of international law. It has violated international law. And cyber operations can violate all sorts of international law rules. I'll put some of them here on the screen. So when you have a private company that is operating under the control of a state and causes damage to the target state's cyber infrastructure, for instance, wipes the hard drives of computers such that the hard drives need to be replaced. You will know that this is what happened in the Shamoon hack case. Then in that case, the target state would say that the state to which we attributed the company's operations has violated its sovereignty. Right, so that's a violation of international law by the state that had an involvement, even though the company was the one that factually carried out the operation. When we have a private company that, for instance, on the instructions of a state, manipulates the election returns in another state such that a person, a nominee, or a political party that otherwise would not have won the elections comes into power, then we would say that this was a prohibited intervention by the state that was involved into the internal affairs of the victim state. So that, again, would be a breach of international law. And so there are various other rules that come from other bodies of international law, from the UN Charter, from diplomatic law, consular law. the law of armed conflict or the law of war that cyber operations potentially can breach. So when that is the case, so we had a private company that was engaging in cyber operations. The cyber operations are attributed to a state as a matter of law and are found to breach a norm of international law. Then the legal consequence of that situation is that the target state is entitled to what are called countermeasures. Countermeasures is a legal term of art, and basically what a countermeasure is that the state whose rights under international law have been breached is allowed in international law to respond such that its response, which would otherwise be a breach of international law, becomes permissible. In other words, one state breaches international law against the other state gets a green card to breach international law back, if you will, in order to defend its rights. And what is the implication for private companies here? In all likelihood, the countermeasure would be directed against the company that carried out the operation. In other words, the victim state may be entitled to engage in disruptive or somewhat destructive cyber operations that in law are taken against the state that was involved, but factually are carried out against the systems of the private company. All right, so these are countermeasures. This is one clear risk that those of you who are business owners or operators should be aware of. Now, when we look at private companies acting autonomously, again, whether they are engaged in some sort of intelligence collection or whether they are engaging in autonomous hackbacks, which, as you again will know, some states are considering legalizing in their domestic laws, then these actions potentially also have international law implications. The first is that the country from where the private company is operating against another state may be found to be in breach of its due diligence obligation. The due diligence obligation says that a state must control cyber activities emanating from its territory, and it must stop those cyber activities that cause serious adverse consequences to other states. In other words, if your company is acting such that it causes serious adverse consequences to another state, the state where you are based is legally obliged under international law to put an end to your operations. And if the state where you're based fails to do that, then the target state of your operation is again entitled to take countermeasures to put an end to your offending operations. So this is again a situation where actually offensive cyber operations may be conducted against a private company. All right, so now if you're a private company and for some inexplicable reason, you cause very serious harm to another state, and you're acting on your own initiative. Serious harm in this context would be harm that is caused to an essential interest of another state. You may be thinking critical infrastructure. Let's say you're hacking into the classified military network of another state with a purpose to collect intelligence. But something goes wrong with your operation, you crash the communications network, and that has operational impact for ongoing military operations of that state. That state would be entitled to say that it is again entitled to respond, irrespective of attribution whatsoever, against that, as a matter of law, against the state where you're operating, as a matter of fact, against your company's infrastructure to put an end to that offending cyber operation. So the state might, for instance, just encrypt all of your systems and essentially halt your operations in order to defend itself. So that is called the plea of necessity in international law. And then finally, the most egregious response that becomes available to target states is the right of self-defense. So if you're a private company and you cause harm at the armed attack level, that's the legal term of art. In other words, we're looking in this case for significant injury, death, damage, or destruction as a result of a cyber operation. Then the victim state, the injured state, is entitled to respond with a use of force. against you. All right. So as you can see, international law has some fairly robust responses to actions that are found to breach international law or to rise to the level of a plea of necessity or an armed attack. So clearly some operational risk for companies who are engaged in those types of cyber activities. And then finally, a few words about a situation where companies might get entangled in war. There are situations where actually private companies may become lawful targets. So let's take the case of a communications company or company that produces communications hardware for Latvia, here in Latvia. And let's say Latvia is at war with its evil neighbor Estonia. So if that was the case, then that company, in other words, its factory would be a lawful, what is called a military objective in that situation. If that company, for instance, produced its stuff, it had its factory in Lithuania, for instance, then the situation would be a bit more nuanced, because in that situation, Lithuania's, it would be the law of neutrality that protects Lithuania from a direct hit by Estonia against the factory. However, Lithuania would be obliged, in order to honor its impartiality vis-à-vis the belligerent parties, to stop the operation of the factory for the duration of the hostilities. So again, if you're a private company that produces stuff for the state that will be used somehow in connection with war, then you are potentially a military objective, in other words, a lawful target in times of war. And now, a few words about legal risk management. So I hope I have shown to you that there clearly are some legal risks that also arise from public international law. What can you as companies do to mitigate this risk? The first step would be, of course, to acknowledge that there is a risk, and not just acknowledge that there is a risk, but also understand the risks. And I'm quite certain that unless you are Microsoft or perhaps FireEye, you do not have public international lawyers on your staff. So first, you need to acknowledge that there's a risk. Secondly, you need to talk to international lawyers to understand what the risks are specifically. Oops. Now, if you are a company that falls within the first scenario, you are acting somehow in cooperation of a state. I would say that it would be wise to avoid situations, to avoid cyber operations that might be characterized by the target state as violations of international law. So if you are supporting a state somehow, if you are engaged in intelligence collection, then even if your intelligence collection is attributable to a state, the target state, in all likelihood, will not say that it was a violation of its rights under international law. So you're on pretty safe ground here. But if you're starting to do some more offensive stuff, then the first advice would be not to do that. However, if for some reason you still decide to go ahead with those offensive operations, what you might think about is having an arrangement with the state with whom you're cooperating that should the target state, lawfully under international law, respond against you, that the state that you are supporting somehow will compensate you the damage that you will suffer as a result of that response. If you're a private company that is acting autonomously, the first piece of advice would be do not engage in seriously offensive cyber operations that are likely to have, say, real-life physical consequences. Here you should remember that international law does not care if you intended those consequences to manifest or not. Remember the example of hacking into the military classified network? Even if you did not intend for those serious consequences to manifest, if something goes wrong, the target state will be entitled to respond. The target state does not have to account for the fact that you made a mistake. And then finally, the most likely scenario, if you are engaged in intelligence or investigative activities, you should remember that international law is the law that gives states the authority to enact and to enforce and to adjudicate their domestic criminal laws. So even if you are hacking into systems in another state from the safe environment of Latvia, the target state certainly has criminalized that activity. You will know of cybercrime laws criminalizing unauthorized access, unauthorized intrusions, system interferences. So that target state will be legally entitled to prosecute you in that case. So it might be wise, perhaps in the case of more serious offenses, not to end up in that country against which you have engaged in those offensive actions. In all likelihood, they can't prosecute you while you are here in Latvia because those in absentia trials are very, very rare. But should you end up in that country in the hands of their authorities, then you personally are at legal risk. And then finally, as a private company, you may want to consider participating in the normative process. Many of you will have heard those statements and declarations from countries saying that cybersecurity isn't only a state problem, it is a societal problem, it is an overarching problem that needs to be solved not only on the diplomatic level, but also by involving academia and the private sector. So to an extent, states are willing to incorporate private sector in this normative process. But you should be somewhat cautious about doing that too aggressively. And because at the end of the day, international norm making is the domain of states. And they, even if they are willing to give the private sector a role in this, that role is not going to be too big. So if you recall, Microsoft, for instance, has called for the development of a digital Geneva Convention. This is diplomatically somewhat of a sensitive issue, although an example of how a private company is engaging in the normative process. All right, any questions? You guys are all more privacy lawyers, huh?
Yes, thank you for impressive presentation, but maybe there are some questions or comments. Yes, please.
Just for fun. For example, just for fun. We know Chinese vendors, they're selling the phones, which somehow are infected with spyware, malware. Should we assume that this is a Chinese government behind it? Should we declare war with China?
All right, so you should certainly not declare war, but the answer is because that activity does not amount to what I called an armed attack. Armed attack is the threshold for engaging, well, you would say war. I, as a lawyer, would say engaging in self-defense. In other words, the authority to use force against the other state. So certainly not a green light to go to war, but can we attribute the Chinese vendors' actions, the selling of the potentially infected devices to the Chinese government? Again, so here we have to ask, are those companies operating on the instructions or under the direction or control of China?
How do we know?
So here, this is a factual question, not a legal question. Although in order to answer the legal question, you will need to know the facts, right? But I think in this case, even if we had more facts, we would not be able to meet those fairly high thresholds. So in this case, I think the answer is no. But if you have facts, if you have intelligence, for instance, then if that intelligence supports to make the claim that yes, the company indeed is acting on the instructions of the Chinese government, then you do attribute to China. But the secondary question is, even if it is Chinese activity in international law, does it breach a legal right that China owes, for instance, to Latvia? And the answer here would be no, because international law does not prohibit the selling of infected devices. So all in all, long answer was that. The short answer is no and no.
One more question?
Yes. how do you think does cybercrime have a potential to become international crime? I mean, legally within the context of Rome statute, etc.
All right. So
Or is it rather a means? Can we think of cybercrime as a separate type of crime, or cyberspace is just a means of committing other types of crimes?
So I would say it's the second answer. Cybercrime is just a different means of committing what is traditional criminal activity, right? But is there potential for cybercrime to become a so-called international crime? In other words, a crime under international law, like war crimes or genocide or torture? Well, it certainly isn't an international crime today. For it to become an international crime, states would need to come together and agree on this. And I think that's pretty unlikely, because it's not considered that egregious of an activity.
Okay, thanks. Any questions? Comments? No? Okay, thank you very much for presentation. We congratulate you, and also small present.